Professor Marko Pavliha comes from Faculty of Maritime Studies and Transportation in Porto Rož of the University of Ljubljana. As I said before, we have a long cooperation between the two maritime associations. We even accepted both Marko and Patrick as our, before we introduced the category of honorary member in our articles, we elected you as a regular member, so back in 90s. Marko did his law studies in Ljubljana, master's degree in Split, where lots of us took the master's with Professor Grabovac and Professor Rudolf. It's a pity that we don't have anymore that program Split. And then he took a PhD degree in Montreal under the supervision of Professor William Tetley, legendary professor, and also our friend and honorary member of Croatian Maritime Associations. He gave us a huge donation of his books, American cases, and he had a double collection at McGill at home, and he shipped it to Croatia. Marko also arranged, I remember, one of the visits of Professor Tetley to Porto Rož, and we also have had him in Split for a lecture, and I'm glad that you will dedicate a great part of your presentation to homage to Professor Tetley, and I hope that your initiative to make a centenary of his birthday in 2 years, both at Tulane and at McGill, a reality, and hopefully some of our members will be able to attend those events. Marko, again, I'm not reading the whole biography, full professor in Ljubljana of commercial transport and insurance law, practical experience in the insurance industry, member of the High Court, member of the government of Slovenia, even Secretary General of the CMI, unfortunately for a very short period, winner of many prizes, including more of those as a lawyer of the year, and he even just returned from India, where he got an award for his humanitarian work. Marko, please, the floor is yours. The title is Hague Rules 101, homage to Professor William Tetley.
Hvala, Igore. Dragi Igore, dragi Gordane, prijatelji, prijateljice, kolegice, kolegi. Velika mi je čast i zadovoljstvo da sam nakon 25 godina opet u ovom divnom gradu Dubrovniku i što vas mogu nagovoriti danas. Puno vam hvala na ljubaznom pozivu. Dear Igor, dear Gordon, friends, colleagues, it is my great pleasure and also honor to be here in this beautiful city of Dubrovnik after 25 years and to be able to speak to you in this impressive international university center. Before I continue, you can hear that I was not only as a person in South India, but also my voice and my health went south, and obviously decided to stay there. And so hopefully I will be able to speak for the next 20 minutes or so, but well, the adrenaline is already in my vessels, and I'm really enjoying to be here and say a few words, not only about the modern or less modern law of carriage of goods, but also some words about my dear supervisor and colleague, the late Professor William Tetley. Well, a few words about the title. The presentation is based on my article, which was published in the European Transport Law last year. This is a special edition which was dedicated for the centenary of the Hague Rules, and there are also articles written by Frank Sterling and I think Frank Stevens and Professor Martinez and some other esteemed scholars. So you could actually get quite a good idea, especially talking to the students about the first 100 years of this important piece of legislation. Well, number 101 in the title has a double meaning. First of all, in August 25, we celebrated the 101st anniversary of the Hague Rules. And also the number typically means an introductory level course in a particular university subject. And indeed, 100 years ago, or 101 years ago, the Hague Rules were the excellent introduction to modern law on carriage of goods. Well, today they are outdated. Thus, the maritime stakeholders need more advanced and sophisticated course on the subject. This is about the title. Well, allow me to go back exactly 35 years ago. It was once upon a time in Montreal, when I came there to take my second master's degree in law, in comparative law, after obtaining one at the University of Split. And I had a meeting with Vice Dean for Student Affairs, Professor Peter Hanapel. Otherwise, I think he still works at the University of Leiden. And he would be the one helping me choosing all the courses for the first and second semester. And he was a bit surprised that I decided to take only one course on maritime law. He said, well, you are interested in maritime law. But at that time, for whatever reason, I paid more attention to environmental law, probably because I worked as a research assistant at the wrong department in the law faculty, Institute for Public Law. And I thought that it would be kind of appropriate that I wouldn't really specialize in the area which the Institute was not responsible with. So Professor Hanapel asked me, but you are aware who is working here at McGill University? Yes, I'm aware. You are one of them, you know, but even then I got a little bit of political sense, you know, how to talk to the people. But I said, yeah, but are you aware that Professor William Tetley is also one of us? And to be frank, I didn't know. I thought that Professor Tetley was Brit, that he was, I don't know, lecturing at Oxford or Cambridge. I don't know why, maybe because of his bow tie or whatever. Yes. So, oh, really? He's here. So to cut the story short, instead of taking only one subject with him, I chose 4 of them. Even the last 2 were called Independent Research 1, Independent Research 2, and it was, I think, 5 or 6 credit points. And of course, the first one was International Carriage of Goods by sea, and the second one was International Maritime Conventions. Of course, immediately after that, I made a homework and I realized that Professor Tetley was really world-renowned expert in maritime law, that he was actually educated also in the Canadian Royal Naval College, that he spent 18 years at one of the very prestigious downtown law firms in Montreal practicing law, so practicing law for 18 years, and then 8 years in politics. He was a member of the National Assembly, and at the same time, this kind of a common law approach, also a member of the cabinet. I think he was Minister for Finance under the government of Robert Bourassa at that time. And in 1976, he joined McGill. Later on, he also started lecturing at Tulane University, and the rest, I think, is history. And I was, first of all, taking various courses under his supervision, completing my second master's degree. And then when I enrolled in the doctoral program, I wrote a thesis under his supervision entitled Implied Terms of Voyage Charters. And as you could see here on the picture, later on, we also became friends. He asked me quite soon to call him Bill, you know, and here Of course, you can recognize him. You wouldn't have a problem to recognize my wife, who is at the moment probably strolling and shopping around somewhere in Stradun. But well, me, it's a bit more tough to recognize, yes, but it is me on the left side. And it was during Professor Tetley's visit to our little apartment in the middle of Montreal. I think that was in December 91, after my oral defense of the doctoral thesis. So it was not unethical, to invite him over. And as a matter of fact, they came the second time when our daughter was born in September 92, and then we decided to live back in independent Republic of Slovenia. Well, Professor Tetley's lectures were a wonderful symbiosis of his practical experience and his theoretical knowledge, and also very humorous. He liked to make jokes. Not many of us really understood them at that time, or very English jokes. I mean, you would know. And for example, Michael, I'm sure you met him quite often. One of them was when he was explaining us his experience before the Supreme Court of Canada. And he said, well, I really tried to impress the court with my long, fat argument, but they really didn't take it into account. It was like 7 against 0. Obviously, 2 judges were missing. And he said, at least it would be, 6 against 1. No, it was 7 against 0. And then Professor Teddy said, it was like getting killed on green light at a crossroads. You were right, but you were dead. So it doesn't help you much. And, I can continue telling these little jokes, even when he came to visit us in Slovenia and in Croatia, and he was so fond of our countries at that time, still in one federal state. And of course, his books are almost divine, if I may say so. I had opportunity, that was in late 1990, before the breakup of the former Yugoslavia, to come to Yugoslavia with the senior partner of the law firm when I was working in Montreal, to visit all the major ship owners, because the idea was, and Gordon would know that because I was also talking to people in Rijeka, your father, and then, of course, George Jukovic, Kačić, and so on. And all the ship owners, starting in Slovenia, Portorož, Splošna plovba, and going then to Montenegro, when I mentioned that I'm writing a PhD under the supervision of Professor Tetley, it was either a CEO of the company or one of the managers, he would stand up, say, oh, you see, I have 2 books or 3 books. There is a blue Bible on marine cargo claims or international conventions and so on. Yes, this is the 4th edition. Unfortunately, he was about to write the 3rd volume on Rotterdam rules. But unfortunately, he was asked a bit beforehand to leave his physical body and go in eternity. But really, his books are a must. I still read them quite often. They were translated in Chinese, in Russian, I think also in Japanese, and so on. So they are really something which one must study in order to get a comprehensive and comparative view of the subject. There are not so many scholars around, adopting this comprehensive and holistic, I would say, comparative approach. For example, Professor Pejovic is one of them. That's why I like your book so much, and some others. perhaps I may say that Professor Vlačić and myself are also doing our best to take this path, because this is really the only possible way, right? Not really to examine each and every tree in the forest. We must understand the forest, and then of course we can concentrate to separate plants. And having said that, I think that the very gist, the conditio sine qua non, before speaking about the law on carriage of goods, is to understand the marine cargo claim. So I would take maybe 5 minutes just to go through it, and I apologize for all of you who, of course, are more than familiar with this. But I always remember when I started working for the aforementioned law firm in Montreal, the first 6 months or so, the only thing I had to do for the senior partners was preparing statements of facts. And I really felt like almost an underdog, statement, give me. I would like to do some serious work, not just, writing down what happened. But I will remind you of the old ancient Roman saying. I think it goes like that: "Dammi facta, dabo tibi ius." Give me the facts, and I'll give you the law. So I was supposed to give the facts to the partners, and of course, then they would do the sexy work, applying the Hague rules, the Hague-Visby, and so on and so forth. For example, a typical marine cargo claim would be as follows. Okay, I think I can use pointer here. Okay. Let's say there is a seller in Dubrovnik of electronic equipment, and he sells one container of this equipment to the buyer in Montreal. And the contract of sale is based on CIF, meaning cost insurance freight, as you know, meaning that the seller has to insure the cargo. And then, of course, the policy would be assigned to the buyer. Because I'm sure that you remember, the risk would pass upon the loading the cargo on the vessel. The old expression of Incoterms was when the goods pass the ship's rail. But then I think in the version of 2020, they changed the wording so that when the goods are loaded, the risk is passing from the seller to the buyer. And that's why, of course, it would be, in the case of the loss during the carriage by sea, it would be the buyer having the insurable interest. So the buyer, and for the ease of understanding, the seller would be considered at the same time as shipper, and the buyer would be consignee. The buyer would arrange the payment at his bank, asking to open a documentary credit at exporter's bank, and so on. So, to cut the story short, the goods arrived in damaged or destroyed condition, and then the buyer would claim the insurance proceeds from the insurer, and by way of subrogation, the insurer would obtain all the rights, and then, of course, it would be the insurer entitled to file the marine cargo claim against the carrier, whose responsibility against is insured with one of the P&I clubs. And then, when you understand these facts, you can actually start reading Professor Tetley's books on marine cargo claim, because he would explain in details and in comparative way what is the order of proof, who has to prove what, and the burden of proof and all other things. The clauses like Himalaya clause and valescular rules and so on. These two volumes altogether, I think they have more than 3,000 pages. So whenever, and Patrick knows that our students are complaining that we speak too much, about maritime law and so on, and it's maybe, I don't know, the chapter on maritime law and carriage of goods in the book of transport law is maybe together, I don't know, 30 pages. I would take the books from our library and show to them, what about this? So is it 30 pages or 3,000? What do you prefer? Now, Michael has already covered all the important stuff regarding the Hague rules and the rest of international legislation. Let me just draw your attention to the number of ratifications, especially within the European Union. Well, as you can see, they were ratified and exceeded to by almost 90 countries. But they are still in force, at least to my knowledge, in 6 European Union countries. God forbids, for whatever reason, also in Slovenia. Our government never decided to adopt the Visby Protocol, and even before, former Yugoslavia, thank that our Croatian friends decided to do that. So I understand that it is the Hague-Visby rules which apply in Croatia, but in Cyprus, Germany, Ireland, and Malta, and Portugal, and Slovenia, it is still the Hague rules. And of course, it was mentioned they apply automatically tackle to tackle, and don't apply to charter parties the carriage of live animals and to the agreed transport of cargo on deck. And of course, the basis of the liability is due diligence, the presumed fault, with several exceptions, with a possibility to limit liability. Without going into details, why the second protocol, well, the first protocol actually, the first amendment was adopted, what it was adopted in 68, and now it was ratified or exceeded by 25 states, including 12 EU members. Croatia is one of them, and probably is not oversimplification to say that the most significant or the most important part of the Hague-Visby rules or the Visby Protocol is a container clause, and of course some other amendments which were already mentioned, and respecting the time limits, and we actually started a little bit later. I will skip that, and that was also one of your suggestions when we received your last email. So the next one is SDR protocol. You're all familiar with that. Again, it is in force in 24 states, including 14 EU members. And the limits and the value of special drawing right. Perhaps just to mention that it used to be composed of 15 different currencies. Now it's down to 5. So it's US dollar, the euro, the Chinese renminbi, the Japanese yen, and the British pound sterling. And it is still more stable than the value of gold, which was used in the past. And then the Hamburg rules. Well, many years ago, I was privileged to speak at one of the Slovenian conferences about the Hamburg rules, and I said, well, is this kind of a symbolism that they were adopted, actually that they entered into force on November 1st, which is, as we all know, how do you call that in English? The All Saints' Day. Or, yes, well, in Slovenian, in Croatian language, we say Dan mrtvih, so the day dedicated to dead people. And indeed, well, it took many years for the Hamburg rules to come into effect. And they are still binding large shipping nations such as Czech Republic, Slovak Republic, Austria, to be a bit at least sarcastic way. So they're really, if you ask me, that letter, and they are virtually non-existing. And I remember again, Professor Templi, when he was talking about the Hamburg rules, okay, it was, let's say, in 89, 90, the rules were not in effect yet. And he said, you know, the best way I can explain the rules is to tell you that they are just right. And of course, we were staring at him. We knew that the joke was about to follow. And he said, yeah, let me go back to the First World War. It was Christmas Eve, somewhere in France, at the front, and the lieutenant of the platoon decided to give the privates to the soldiers 20 liters of red wine. So he would call up his sub-lieutenant and say, listen, drink the wine, drink it up. Now it's a ceasefire for 24 hours, and of course, then we will continue killing each other the day after and so on. Not funny, but this is the way it was. And the next day, the lieutenant, you know, proud of himself, I mean, you know, was calling his sub-lieutenant, said, how was the wine, by the way, you know, and hopefully you got some food as well. And the sub-lieutenant was a bit nervous, you know, didn't know how to reply, and said, well, sir, it was just right. A very British way. Said, what do you mean it was just right? Well, if it were any better, you, the officers, would keep it for yourself, you know, you would drink it up. If it were any worse, it would be completely undrinkable. So the Hamburg rules. Perhaps Tetley was even more suspicious whether or not they would ever come into effect, but they did in 92, but he continued criticizing them, and he was still very skeptical about that. And who knows what he would write in the 4th volume of Marine Cargo Claims about the Rotterdam rules, which are not yet in force. I don't know if it is still correct that they were ratified by 5 countries only, including Spain as the only member of the European Union. My opinion, and it is not, I think, alone, is that the rules are, of course, a giant work done by CMI and UNCITRAL, but maybe even a little bit too giant. You know, they are extremely complex. I probably read them 5 times, and I'm still confused, perhaps on a higher level, but they are difficult. They are very complicated. For example, to give you a feeling, they are containing 96 articles in 18 chapters, which is much more than the Hague-Visby rules, 10 articles altogether. Okay, they are long articles, but nevertheless, the Hamburg rules, 34 articles, or the multimodal convention, 40 articles. So, and of course, quite a few new terms. We discussed that in extent in the past, and also we will, even here at the conference. So the remaining question, or the last question, is what are options? What are our options for the future? There are probably more. I came up with 4. Well, the first one is that the Hague-Visby rules, as amended by the SDR protocol, should be ratified or exceeded to be the vast majority of all countries, at least to start with. For example, our maritime code is based on the Hague-Visby, despite of the fact that Slovenia has never ratified the Visby protocol. The second option, perhaps, is that the multimodal convention could be revived. That was one of the Tetley's idea, perhaps refreshed, you know, amended to attract more support from international community. The third, probably the worst option, is that the shipping world should accept the Rotterdam rules just in the present forum as they are, but, you know, 5 ratifications so far and 20 required. And the fourth one, which is my favorite is that we need to amend the Rotterdam rules to make them acceptable to the maritime industry, and several proposals should be reconsidered, including the one argued by our esteemed Croatian colleagues, Petar Kragic, where is he? Oh, he is here, yes, and Diana Ierolimo. And again, as I said already last year in Trieste, it is a tiny book, Lex Mercatoria, but one of the best I ever read on the subject, really. So I strongly recommend it for those who don't have it. It's a major work, and it also provides arguments how to amend the Rotterdam rules. For example, cargo liabilities should be channeled solely to contractual carriers. The rights of claimants should be protected by mandatory marine insurance and direct right of action, and so on and so forth. So let me conclude with my proposal, which was kindly announced by my friend Igor. In 2027, we will mark another centenary. It will be the 100th anniversary of Professor William's birth. So he was born on 10th of February, 1927. And I strongly believe that as he is one of the world's greatest maritime law experts ever, we should do something significant to cherish his academic inheritance. So I would kindly ask you, friends from Croatia and United Kingdom and the United States and around the world, also Japan, of course, to support the idea that we would organize a one-day symposium at McGill Law Faculty in Montreal. That was his alma mater, so to speak, although he never studied at McGill. He was just teaching there. And also, a few days before, a few days after, it's not so difficult to travel, at Tulane Law School in New Orleans, perhaps in June 2027. And I already wrote a preliminary letter to then Dean of the McGill Law Faculty. Unfortunately for us, and well, fortunately for him, he's not Dean anymore because he was elected as the Supreme Court Justice in Quebec. So we'll have to wait to see who will be his replacement, because at the moment there is only acting Dean. And I also wrote to the president of Comité Maritime International, to the presidents of the Canadian Maritime Law Association and the Maritime Law Association of the United States, and also at Tulane, to suggest to organize this event, bringing together maritime lawyers, colleagues, and friends of Professor Tetley from all over the world. So perhaps the best way to approach is if we intend to adopt some sort of a summary of our conference minutes, whatever we call it. I don't want to call it a petition, but perhaps if the message goes from this distinguished podium audience to the president of CMI, I think it is really the CMI who should take it over from here, perhaps to combine this event with any other CMI events and to organize this anniversary. Because I also think that it is better to celebrate birth anniversaries than death anniversaries. There are quite a few holidays in Slovenia when we are celebrating, the day when somebody died. And okay, coming from India, I can say what's wrong with dying is just leaving the physical body, but still we are in Western part of the world. So yes, this is about it. And thank you so much for your kind attention. And again, many thanks for inviting me. Dubrovnik is beautiful. And of course, I may say, as many of you have already done in the past, I'll be back. And this is not a threat, this is a promise. Thank you so much.